My name is Olivia Wann, and I'm with the law office of Olivia Wann and Associates. In today's discussion, we're talking about should you give money to your children to spend down your bank accounts if there's concern that you will require long-term care? That's a great question. Let's first establish the difference between the IRS rules as it relates to gifts versus the state's Medicaid rules, because there's quite a bit of difference there that can cause a lot of confusion and misunderstandings. So the IRS sets limits on the amount you can give another person without paying gift tax. And for year 2025, that amount for an individual is $19,000. If you give beyond $19,000, then you would be required to pay the gift tax. The donor, you, would pay the gift tax. I want to mention also that the gift tax amount is quite substantial. It's between 18 and 40% tax. I also want to point out the lifetime gift exclusion ties directly to the federal estate tax. This exclusion amount is the amount of money or value of property that you can give away during your lifetime without being subjected to federal tax. And for year 2025, that amount is $13.99 million. Some of the states have a different estate tax. For example, the state of Illinois has an estate tax, whereas Tennessee does not. It did away with estate tax in the year 2015. None of these numbers correspond, though, with Medicaid eligibility. It's a completely different thing to contend with. If you are attempting to deplete your bank account or monetary resources or even real estate during your lifetime, anticipating that you're going to require long-term care, keep in mind the 5-year look-back period. So if you're applying for Medicaid, the state's Medicaid program, such as TennCare, would look at your financial documents for 5 years prior to application. So if you're giving property away, that could be problematic. And the reason it comes up, as we discussed in a previous video, Medicare, which is the federal program, only provides a total maximum of 100 days of long-term care. And after that time period, you would be paying for your long-term care out of pocket. And that means once your money is depleted, then you could make application to the Medicaid program. So any gifts that you make for no fair market value could be caught up in this 5-year look-back period. And that means that Medicaid would not provide benefits in accordance with the penalty period. That penalty could be days, months, or even years, depending on the value of property that you had given away during that 5-year look-back period. So think of the situation that could come up where a parent may have given money to their children, not realizing that they would be penalized for benefits. And then the money that they gave away, if it's spent, well, now who is going to pay for that individual's long-term care? The money may have been long spent, is no longer available. Who will pay for the care, or who will provide the skilled care for your aging parent who is in dire need? So before you make serious financial decisions such as this, please consult a CPA or your financial advisor on these tax rules, your tax professional, or an attorney that's familiar with estate planning. Thanks for tuning in.